marrying a U.S. citizen or marrying a lawful permanent resident. In this video, I am going to talk about the choice that you have to make. I'll give you a 10-minute consultation so that you can make an informed decision. My name is Bijoux, Ngwanda, I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're into my channel, please go ahead and subscribe. But if you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, again, please go ahead and share, like, and don't forget to comment below. Also, please follow me on Instagram because we're talking about employment-based immigration. We're talking about investment. We're talking about self-petitions. Okay, let's get right into the subject. Lawful permanent resident or U.S. citizen, which one? Okay, so the real question first of all is, am I free to marry, right? Because you will be surprised that sometimes people are not free to be married. Why? Because their previous marriages were not legally ended. The divorce was fake. We have seen that before, okay, with our former clients. So that's why we have to be a little bit conscious on our decisions, right? Am I free to marry? Yeah. If you're single, yes, you're free to marry, but you have to check for your partner as well, because some people, they'll lie to you that they're single, but they're not really single. You can check the database, you can check to find out whether or not they're really single and free to be married, or whether or not the divorce is a real divorce decree. Sometimes they got a divorce, but they did not get the actual decree and did not submit it with USCIS, and then the petition later on get denied. So after we cover up that question, right? Let's say you answer that question positively. Yes, I am free to marry. Now you move on to the second question. Am I within a lawful non-immigrant status? Okay, am I within a lawful non-immigrant status? Simply means that am I legally present, lawfully present in the United States? If the answer is yes, then it doesn't matter. You can marry a lawful permanent resident or you can marry a U.S. citizen, okay? Because at the time of adjustment, okay, the time of adjustment, the time the adjustment is filed, well, you have to be within lawful non-immigrant status, lawfully present in the U.S. Once you pass that question, then you go again to the third question. Am I admissible? What type of visa I came with, okay? If you're admissible, so let's say no criminal or felonies, crimes, stuff like that, you came with, let's just assume you came with a dual intent type of visa, H1, HB. So yes, you are free to marry. Yes, you are admissible. Yes, you are within a lawful status. Now it really doesn't matter whether you don't really have to wait for your future spouse to become a U.S. citizen because you are within lawful status. Adjustment of status is possible in the U.S. But let's say that you are not within a lawful status and your spouse is not a U.S. citizen. He's a lawful permanent resident. Can you still adjust status? My friend, unfortunately, you are going to be required to go through consular processing. The way it works, you file for a I-601A, unlawful presence waiver. You wait for it to be approved, and once it is approved, then you go actually outside of the United States. Of course, after the I-130 was also approved, right? Then you go outside of the United States to get your visa abroad. What are the consequences? There's no guarantee that they have to grant you a visa to come back. Really, there is none. The acceptance or the approval, it just simply means that they really waive your unlawful presence. But when it comes to consular processing with their eligibility requirements too, you have to meet that. And sometimes we have seen one person really being granted a lawful permanent, being granted a I-601A waiver, went outside. That's a client from Nigeria, went outside and got stuck there, okay, because the Nigerian, not the Nigerian, but the U.S. Embassy in Nigeria refused to give the visa, the immigrant visa. So what we had to do is to fight, right? We had to fight the denial, we had to file another I-601 waiver of extreme hardship to the spouse here, so that they can grant her the visa. And you know, those I-601, it takes forever too, right? She was stuck there for at least 1 year, okay, before coming back. At least we're successful, so that's why we want to make sure that you understand the difference. What are we advising? So if you can wait for the future spouse to become a U.S. citizen, it's much or less burdensome. It's better. Why? Because you will not be required to leave the United States, provided that you meet other criteria, right? You came with a good visa, admitted, inspected, or parole in the United States, while you don't have any other inadmissibility that requires a waiver, except for unlawful presence type of thing. So then waiting is much better, because at least you are still here together, avoiding extreme hardship, and just wait. The person becomes a U.S. citizen, and then you file your application for adjustment of status, and hopefully it gets granted, provided that the marriage itself is a bona fide marriage. We have talked about bona fide marriage before. You can just go ahead and refer back to our previous videos. So in conclusion, okay, what is better? It is better, if you are not within a lawful status, to just wait for the spouse or future spouse to become a U.S. citizen. It's much easier for you, less stress, okay? But still, you can still require a I-601 waiver, and because sometimes you have to wait for 4 years, or you know, you don't want to wait, then you can still ask for a I-601 waiver, hope for it to be granted, get out, and do consular processing. But at least we have provided you with some ideas, so that when you make your decision, you make sure that, of course, that decision is well informed, okay? Bijoux Ngwanda here, immigration lawyer. If you need a consultation, please call 202-751-2180. Email bijoux.ngwandaesq@gmail.com. You can also click the consultation link in the description box below, and just schedule a consultation on your own time. Until next time, bye-bye.